Good morning. What is this? November 1st. And we welcome Alex Egner for I think you're the first tree-peat. You're the first
No.
trifecta. No.
Second time.
Are you sure?
That's what it feels like.
I think we did 2 at the Candy Factory.
You know what? I'm going to take credit for 2 then.
We did 2 at the Candy Factory and 1 here. But anyway, whether it's 2 or 3, why don't you talk a little bit about Chieppor Egner?
Okay.
And your practice and what you do and what kind of cases and what counties you cover.
Great. That's a good. I guess my name's Alex Egner. Obviously, I am a practicing attorney here in Lancaster County. I have a partner, John Chieppor. So our firm is Chieppor Egner. We're located in downtown Lancaster, and most of our practice is focused in Lancaster County. We have a heavy criminal defense practice. So let's say a lot of our clients are criminal defense clients. But we do a number of other practice areas. I do firearms restoration, which is sort of a unique practice area, and I do that all across the state. And so I find that because there's maybe 150 firearms restoration petitions filed in the state every year, if we're doing 15 to 25 of them, that has to be across many counties in order to do the cases and familiarity with their experience and what our clients need. So that's a big practice area for me. Professional licensing defense. We normally do those for our criminal defense clients. So there are other reasons why someone might be before a board for a licensing issue. But most of the time it comes into play for my practice area because this person has a conviction or has gone through ARD or has gone through an investigation or arrest and are up for some sort of renewal or revocation or suspension of their license.
I think when you were talking about the statewide nature of firearms restoration, I was also thinking, to me, as a trial veteran of decades, it's sort of nice to get it out of the county level, where sometimes there's personalities at work. It could be the judge, could be the DA, could be the defendant, could be the defense.
Yeah, I think that those relationships are important, and that's the kind of thing that when you're a county practitioner, you have at the county level usually.
I also was thinking that when you're defending somebody in the Court of Common Pleas, it's always with an eye towards how well are we going to do if we go to trial, and can I beat the burden of proof? Because the Commonwealth has to prove things beyond a reasonable doubt, but there's also the presumption of guilt when you're walking into a courtroom with somebody beside you that's been charged with a crime.
For the firearms restoration, you really are in a good position. The state police is very rarely going to have lots of evidence or testimony. I mean, I get to build my case,
right?
Of this is what I want to say. And again, a lot of times I think it's the feeling the judge gets. If we have you prepared well, you present well to the judge, we have some really good information about you to give the judge. If the judge leaves there and thinks, you know what, this is someone who I'm comfortable with, that's a good way to get a feeling. Instead of a judge saying, is this beyond a reasonable doubt? Do I have any pauses or hesitation here?
How much did I just pause?
Yeah, how much did I just pause? That's great. So that's a very comfortable standard for us. Licensing can be difficult, right? I mean, licensing can be difficult because throughout the process, again, those presumptions change, and you could go through a lengthy investigation process, a lengthy negotiation process, reach an agreement with the prosecutor, and the board can still say, you know what, we don't want to do that.
Yeah.
And they're going to say reasoning why they don't want to do that. But that is a more difficult process for that kind of back and forth.
If the professional licensing board goes against something or just says, no, we're not going to do that, is there an appeal? Or more importantly, can they reconsider it after a year or 2, or there's a change in circumstance?
Yeah, great question. I think reconsideration is always an option. I think I have had very few experiences where we've gotten to the board level and the result has been such that we decide that we're going to seek some other result or reconsideration down the road. So I try to caution people not to make any decision or to seek this without having some time and some things that we can show in distance between what happened.
And the board might give you some indications when they decline to issue a license as to what they're thinking about and when they might reconsider.
And sometimes you'll see probationary license. Hey, we're gonna grant you the license, but you're going to be under these type of restraints for this amount of time. I think that's a good result for a lot of folks. If you're on the edge and you're saying that's not who I am or whatever, they give you a chance to say, well, prove it to us. You're saying you're going to be a great real estate agent. Show us. You're going to be a great nurse. We'll prove it to us. And I welcome that burden because I'm usually confident in my clients that they're going to overcome those things.
I will handle misdemeanor and felony convictions and filing pardons and giving advice on what can be cleared and when through the use of pardons, clean slate, and expungements. But when I get a question about a 302 commitment, I get a question about firearm restoration based on 302 disability or a PFA or whatever, I immediately just send you get the emails.
Oh, yeah.
I just refer them to you because that's an area of the law that I don't understand. I think sometimes it involves going to a courtroom, and I'm not going to do that anymore. So just give us like an overview. I guess we should start with maybe PFAs. What do you do when you get a referral for a client that has some sort of PFA?
Yeah.
They want to know if their gun rights can be restored.
So there's different reasons why you might have your gun rights suspended, and you've kind of hit the nail on the head, right? PFAs is one of those reasons. PFAs are actually one of the easier processes. Your gun rights are not available while you have an active PFA against you.
Okay.
An active final PFA. A temporary PFA or a PFA that is no longer active are different situations. There's actually not a whole lot we need to do normally. If the court is operating correctly, once your final PFA is over, you should be eligible to go back and purchase. Now, the problem that we run into is PFA is over, you go to purchase, and for whatever reason, you're still being dinged in the system. Hey, this person has a PFA.
Right.
And then it takes a step where we take an administrative process, gather some records, go to the state police. Hey, nope, here's where we're at with this. Please, restore his rights. And that's kind of an administrative, little back and forth with the state police to kind of get that resolved. But that's something that once the PFA is over, the process is in your favor, which is not always the case in firearms restoration.
Is that anything new about that, or is that just the way it's been?
The temporary and finals have been treated differently previously, but whenever there's a PFA that you're currently under, firearms is a big issue.
Well, right. You're just not going to have one.
The way to treat them afterwards for firearm rights is different. There's a different process for an expungement of a PFA. A temporary PFA can be expunged through an expungement process, whereas a final PFA cannot. And that might be kind of the difference of what had occurred previously.
So you're saying that firearm rights could be restored if you don't have an active PFA, but actually expunging the record of the fact that you had a PFA is a different issue.
Correct. Yeah. And so a lot of times people get them conflated. They call, hey, I want an expungement. And I say, okay, well, why do you want an expungement? Well, I want an expungement to get my firearm rights restored. Okay, well, we might not, I can understand why you might want an expungement, and that might be eligible for you, or a reason you can go down that path. But you might also not need to do that. And that's the same with 302s. People will call a lot and say, hey, I want to get my involuntary mental health commitment off my record. And that's a process, and it's an available process for a lot of people. But also, sometimes the core of the reason they want to do that is to have their firearm rights restored. And the restoration process, as opposed to the expungement process, is a simpler, faster, cheaper option than going for an expungement of a mental health commitment.
If you get a referral for somebody that had a 302 commitment first time, what's the process when you have somebody coming in and saying, I want to either have my firearm rights restored as a basis of the disability from a 302?
Yeah.
How do you proceed with that?
The first process is we like to look at the case and say, okay, where are you at now? Who are you today? Because the standard for the firearm restoration for a involuntary mental health commitment is, are you a danger presently to yourself or others? This process reflects who you are today as opposed to who you were 15 years ago, or what kind of position you're in now as opposed to what happened 10 or 15 years ago. So it's a good place to start for us. I like to get an updated mental health evaluation. I like some time to have passed since the involuntary commitment. And I like to gather those good things about you. Once we have those gathered, we put together a petition for the local county judge. We go to the county judge and say, this person is not a danger to themselves or anyone else. Please restore their firearm rights. We usually have a hearing. State police does the response to that. They bring a lawyer, sometimes some records they bring. And we put you in front of the judge and let you talk to the judge. We put some other folks in front of the judge, let them talk about you. And the judge usually makes the decision right then and there. Are you someone who I believe is a danger or not? If the judge says, hey, I think that you're an upstanding member of the community, I'm not concerned that you're going to hurt yourself or anyone else, he or she signs an order granting the restoration of your rights. That goes to the state police. The state police sends it to the federal firearms checking system. And then your rights are restored. You can go purchase.
Okay, a couple of things.
Sure.
What's the burden of proof at that hearing?
Yeah. The burden's on us to prove that you're again a safe member of the community who's not going to hurt yourself or anyone else.
Is it preponderance?
Yes, it's got a 51% standard, but a lot of times, I find that a lot of the evidence we're putting on is about your life, and it's
Right.
us talking to the judge. So the feeling the judge gets, the impression the judge gets from you, from the information we're providing about you, I think it carries the most weight. Very rarely, let me put it like this: very rarely does the state police bring any evidence. Very rarely do they have any witnesses that are going to testify. It is almost solely the evidence that we are providing.
So the state police get to cross-examine your witnesses and question your evidence. Are they always unanimously opposed?
So I would say consistently the state police's position has been what I would call a matter for the court, which is sort of, Judge, we believe it's the judge's responsibility to make the decision. We're going to try to give you as full a picture as possible based
Okay.
on our cross-examination. But at the end of the day, we're not saying yes. It's not something where the state police is going to say yes or no. It's something where they're going to provide information to the judge and say, Judge, you make the decision.
And backing up a second to the PFA restoration of rights, what is that? What is that burden of proof? Is it the same?
Yeah. So again, that's a different process. That's an administrative process where if you've been denied, you are most likely actually eligible based on whatever records we have. And it's a process where we would go through a reviewer or a clerk at the state police who would look at our records and say, hey, we've made the incorrect decision. And that has an appellate process that goes to the court system. But very rarely do we need to go that
Right.
step. I mean, the other big piece of it is convictions, right? So we talked about mental health commitments. We talked about PFAs. Convictions is the other reason why people are denied their firearm rights in Pennsylvania. And there's a list of prohibiting offenses in Pennsylvania. And there is the ability under the Pennsylvania statutes to, after a period of time, ask for restoration based on the time that's gone by and the position of those cases.
Are you telling me that if somebody has a prohibited conviction, that even before it's pardoned by the governor, you could have your gun rights restored?
For a very unique set of charges and a very unique set of timeline and circumstances, that is correct. I almost always recommend going for a pardon or an expungement if you have those limiting factors, because while the state can make it so that you have state rights,
Right.
unlike the mental health commitment where the state sends this to the federal government, that is not the case. So the types of charges and the types of circumstances where we can restore you in the state and you are not already affected federally is a very limited set of circumstances. So it makes much more sense, except in a very few set of cases, to go for a pardon and expungement and then come back for your firearm rights afterwards.
When you talked about an expungement for either a PFA or 302 or whatever, are those things filed in the prothonotary or the clerk of court?
Those are prothonotary, right? Those are civil filings.
Right.
And in fact, a lot of counties do treat the mental health commitments a little differently. Sometimes they appear in orphans court based on the structure of the county.
Yeah, that's interesting. And in general, you've done these restorations in different counties?
Yes. I think I want to say 26 counties out of Pennsylvania 67.
Nice.
So we're getting, I tried to get the postage stamp out. I got Erie County,
Right.
down in the southwest at Philly and Delco, and then in the northeast. So I tried to get my corners done first, but I'm looking to fill in the rest of the map when I can.
Yeah, it's good work. It's necessary work. What can you tell us about recent changes to professional licensing?
Yeah. Well, I guess a lot of the professional licensing goes back to Act 53 of 2020 is kind of where we first start with how convictions, a standardization of how convictions are affecting people's professional licensing. So kind of professional licensing, to kind of give a little bit more of an overview, is your barber, your cosmetology, your real estate, your nurses. A lot of different professions have some sort of licensing through the state. And Each of those types have a board that's assigned to them where they review the potential applicants or your renewal applicants for their professional licensing. And when you have that system, there are convictions obviously that have an impact. And each board has a list of offenses that could cause someone to have their license suspended or revoked or denied.
Right.
And there is a different standard of each of those, for each of those boards, for which offenses may have some sort of count against you,
Right.
and sort of presumption that you should not be issued versus a presumption that you should be issued your license. And that process is a relatively more recent process. I said Act 53 of 2020 has changed the way we review those things. So generally, you receive charges or you have charges on your record. You're looking to apply for a license. There are a few things you can do. First, we can check what type of charges you have. And I, as a criminal defense lawyer, if you're coming to me and you either want to be a nurse or you are a nurse, one of the things I want to think about during our negotiations, during our resolution of your case, is how might this impact, your licensing, your renewal, your future application. And the presumption is not only based on what the charges are, but some of the circumstances around the charges.
Right.
If they involved your field, right? So if you're a real estate licensed individual and the charges involve perjury or falsification of documents, that's a presumption that's going to hurt you a little bit.
Right.
And we take that, and if you're someone who's applying or going to be renewing, one thing we want to do is there's probably a notice requirement that you let the board know, hey, this is what's going on. The second thing is we can do a predetermination letter. And that might be what we're talking about.
Right.
Yeah, so predetermination, where we can send the board notice through the PALS system, which any licensed professional is probably familiar with, and say, hey, this is who I am, this is the board I want to talk to, and this is the circumstances of my convictions. Now, what's really interesting, I was on the application and reviewing things for a client, and I believe the question on the application calls for conviction information. But I think that's absolutely an opportunity for us to say, here's our situation, and what would you potentially do in this situation? And we'll get a response from the board about potentially how they would handle that in a predetermination. So it's a very good first step after the step of us looking at what the charges are and your circumstances.
How long does that whole process take?
Yeah, so professional licensing in general can be a drawn-out process, especially for someone who's saying, I want to do this, I'm looking at a job, I have pending applications, or I'm finishing school. And so it can be frustratingly long. A lot of times there's an individual assessment and an individual evaluation of your circumstances. The entire process has a number of steps with a number of individuals. If a board is going to review your license or deny, there's some sort of complaint or initiating circumstance. After that is some sort of individual assessment and investigation. After that, then your lawyer would get involved with the lawyers from the people who are prosecuting you, and we would maybe reach an agreement, maybe not. If we don't reach an agreement, then we have a hearing. And then the hearing or the agreement goes before the board, who makes the final determination. Do we want to go along with this agreement? They don't have to. Do we want to go with the recommendation from the hearing? And so this is a several step process. And so I always advise, if this is something that could potentially be a concern, it definitely makes sense to talk to a lawyer early, to figure out the process or the steps you're going to take or what the plan is early on, because you're in for a number of important meetings and decisions you're going to need to make throughout it.
Yeah, it all sounds very complicated. If there's an initiating procedure of some sort, that's going to crank up some division of the state government to start exploring and researching and responding to someone else, either a licensing agent or counsel for the Commonwealth, trying to figure out a reasonable position. And there were some changes to the professional licensing this year, wasn't there?
A lot of the process as it goes through, there are, because Act 53 of 2020 is relatively new, we are still developing the process for which the standards we are reviewing. I mean, prior to this, there was, it would have, the presumptions and other things were more difficult to ascertain, without having done lots of cases or lots of test examples and things being a little less equal or a little less standardized. Now we certainly have a more standardized process that's becoming more standardized as we move forward, which I think is better. It's good for anyone who's trying to make a determination of how am I going to treat my future profession.
Right. I always want to know about the burden of proof. You have a hearing in front of the board.
Yeah.
You're trying to get a clearance or whatever.
Yeah.
Who carries the burden?
It's preponderance, 51%. Yeah. And again, there's a presumption either for you or against you based on the circumstances of the charge and the type of charge.
Well, I would imagine it would start out with an initial disqualification because of an offense, given the licensing, and then you carry the burden of saying, yeah, but not in this case.
Sure, but there's also circumstances where I've got an ARD for this type of offense. I'm making you aware of it. The presumption can be in your favor.
Yeah.
And the board can be the one, or the prosecutors can be the ones, trying to go the opposite direction. No, you should be suspended because of X, Y, or Z.
That's all really, really interesting. I get lots of calls from nurses and people in the medical field.
Nurses are a big one. They have a very active board. There's a number of nurses in Pennsylvania. Right. So I'd say a majority of our licensing clients have been nurses.
Yeah. Now I didn't tell you we were going to talk about this or anything, but I also get a lot of calls from people that want to go to nursing school, but for instance, they might have an old felony or something. And naturally, they're worried about whether they're going to be able to practice once they get their degree or their associate's degree or whatever. But are you familiar at all with education and the educational standards of allowing somebody to go to a nursing school if they have a conviction?
And that's when something like predetermination really comes in handy.
Right.
And again, talking to a lawyer comes in handy because I can look at the charges and the circumstances and say, is the presumption against us or is it with us? Which is a great first step to know.
Yeah.
And we get that predetermination, and then we know what we're dealing with. The law has a number of circumstances where even if you have that old felony charge, that things can still, it doesn't mean it's going to be disqualifying. The amount of time that's passed matters.
Right.
That's right in Act 53, which is helpful to a number of people. As far distant from the profession you're seeking as possible,
right,
is always a good thing for us to have. And again, when I have clients who are facing charges currently, part of being a criminal defense lawyer or having a criminal defense practice is saying, okay, how will this affect things potentially? What are our potential outcomes that could have a better result? Are there charges that would make sense to negotiate on this rather than this, even though it might not be a traditional avenue that we would look at for someone else?
That's all interesting. I know that ARD is always available as a diversionary program, but sometimes it changes as to whether the district attorneys are receptive to accepting a client into ARD or not. Like, for instance, they used to put marijuana felony deliveries into ARD, but then there seemed to reach a point where they were like, no, that's for misdemeanors anymore.
I think there is changes. I think things go through cycles. The district attorney herself is the person who approves every ARD application, from my understanding the process. And so, there might be differing opinions throughout someone's career as a district attorney or of what would make someone a good candidate for ARD. I think that they try to, as much as possible, give an individualized assessment. And one of the reasons why I say that is when you apply for ARD in Lancaster County, right, you do an application with some information about yourself. You give a chance to make a little bit of a statement. But if you are denied, I can request either reconsideration or a panel. And a panel is a great option for people who are sort of on that edge where there might be some concern of, is this person a good fit for ARD or not? And I ask for a panel. That's a great opportunity for you and I to do some prep work, to go in and speak to the district attorney's office and say, this is who this person is, and here's why they are a good fit for that program. And I think that weight of individuality really helps, especially in cases that are, maybe a little bit more concerning to the district attorney's office about whether it makes sense for them to be in the program or not. And
is the panel still comprised of like 3 assistant district attorneys and someone from probation or something?
There's no hard and fast rule, but traditionally you have the nail on the head there. There's usually 3 district attorneys. There's usually someone from maybe victim witness advocacy, which is a department of the district attorney's office. There's usually a detective or some sort of law enforcement presence. Frequently there's someone from probation. There are different versions of the ARD panel. They will try to get you an ARD panel group that's associated with the type of charge. So if you're there for domestic violence related, you might have some folks from the domestic violence team. There for DUI, you'll have some folks from the DUI team. Or if it's a general situation, maybe a more general a group of attorneys and other individuals.
I'm reminded a couple of years ago, my client had received a pardon from the governor. I filed an expungement in Carbon County. Um, Usually the district attorneys don't oppose it and the expungement order can just issue. But in this case, for whatever reason, I'm driving up to Carbon County to have a hearing, and I walk into a courtroom and it's just the public defender and an assistant district attorney, and the judge is on the bench, and we're the only 4 people in the courtroom. And I walked in and the public defender said, "Hey, what is this?" And the DA's like, "Yeah, what is this?" I said, "Well, it's an oversized piece of paper. This is a pardon from the governor, and they've been forgiven by the governor. And now this is an expungement petition asking the court to order that the state police expunge the entire criminal record." And the judge overhears this, and we're not actually in session yet, but he's like, I really can't do anything about that, can I? And I said, "Well, Your Honor, it is executive clemency from the governor of Pennsylvania." I said, "It would just be best to sign the order." And he looks at the DA and he goes, "What do you think?" He's like, "I don't think you can oppose it. Like, just sign it." And the public defender, I'll never forget, she said, "I didn't even know you could clear a criminal record in Pennsylvania."
Wow.
So there's a lot of people in Carbon County that have convictions that they don't know can be pardoned or expunged.
Yeah. I've had similar circumstances. I think of Pike County. I got up there, and firearms restoration is a closed hearing. And again, judges might not know that when you get up there. It's a county with 2 judges, 2 courtrooms, and I come in and it's a miscellaneous court day. So they've thrown us in a miscellaneous court day. So half the defense bar, which is a couple of attorneys, is there. You know, there's the district attorney's office is down there. The probation officer's down there. They call our case, and I said, "Judge, I'm sorry, but this is supposed to be a closed hearing. Could we clear the courtroom?" And the judge, what is this that we're doing? Why do I need to do this? And so it was a little bit of a learning curve for some of us who hadn't had that experience before.
Those are the kinds of interactions that I like because it's less about litigating. Like when you can have a public defender and a DA and a judge all asking questions about a procedure that you happen to be very good at and very knowledgeable about. It's like, yeah, let's just talk about this like lawyers. We're all lawyers here, as opposed to the normal criminal defense where you're always worried about the outcome for your client. How is this going to change their life? The DA is opposing, the judge is going to rule usually in favor of the DA, and it's just much more of a litigious, stressful kind of thing.
What I would think for my firearm rights clients and your pardon clients, they probably are in a similar place in life. When a criminal defense client comes to me, they have just experienced probably one of the worst days of their life. They're under work stress, life stress, maybe financial stress. They have a lot of negative things going on in life. When I'm working with a firearms restoration client, and I would assume a lot of pardon clients like this too, they are in a good place. They're in a place of, this is who I am today. And yeah, 20 years ago, 10 years ago, I had this awful thing that happened. But this is who I am today. And that is a great experience. So instead of the urgency of, we are in emergency mode, how can we fix things right now?
Right.
We're in repair mode. How can we restore?
It's redemptive.
Yeah, exactly. And so it is very heartwarming to have someone get up and talk in front of a judge. Judge, this is what happened to me 20 years ago. I had this awful experience where this person in my life committed suicide, or I was in a drug addiction.
Right.
And today, I've got my master's degree in this field, and I'm working in this field, and I'm happily married, and I'm involved in my kids' t-ball team. And that is I'm getting goosebumps right now. It's a good feeling. And and to get to be able to share that with a judge.
Well, right.
To share that story.
And the client gets to see the judge in a different way. And the judge gets to sit and be a listening interactor with the defendant, because the client's previous experience with a judge is being put in front of him, told all his constitutional rights, being sure he understood it, and then the judge deciding what it is and then issuing a verdict and sentencing and maybe off to jail or at least a change in circumstances. So coming back around to see a judge sitting in a more restorative capacity, it's just, it's the same with a pardon. Yeah. When somebody gets a pardon and then they get the expungement, I remember this one guy had some felonies, pardoned and then expunged. He was a outdoorsman up in Alaska, and he actually was crying a little bit.
Oh, man.
And he's like, "Mark, I didn't think this was going to work. I didn't think this was going to work. I have all my rights back." I said, "Well, look, it took 2 to 3 years. Wasn't fast, but it's much more restorative in some of the areas that we work in."
Well, and for the long pace, again, restoration takes a while too. I always think, 10 years from now, the 1 year it took, the 2 years it took, the amount of time it took, in hindsight, that's going to seem like a short time.
Yeah. Hey, is there anything else you wanted to cover?
So what's the timeline that you do? I know we try to avoid hard and fast rules as much as I can. What do you try
I'm
to
very
say?
comfortable with the loosey-goosey rule. I just had 11 clients, I think, go through the most recent public sessions in October, and I averaged the time from when they had filed, and it came out to 2.2 years, with the short expedited guy being 1.5,
Wow.
and one of the longer felony guys being 3.5.
Okay.
So it was 1.5 to 3.5 with an average 2.2 for my clients.
Mhm.
Now, also in this phone call to the secretary of the Board of Pardons, she was very candid in saying this is going to be a 3, 4, 5 year process because thousands of pardon applications are being filed as people become aware of the fact that misdemeanor and felony convictions can be excused. But every pardon that's filed goes into a state agency, it gets investigated, it gets auditor assigned by probation and parole, it gets vetted, and the 5 board members, they're 5 people that only get together about every other month, and they'll get together and review 120 cases in 3 days.
Wow.
With these 5 to 10 minute video Zoom interviews. But there's a bottleneck there,
Yeah.
because they are the ones who have to recommend it to the governor, and they only get together so often, and they can only do 120. So until some part of that process changes, hundreds of pardons will issue every year, but hundreds or thousands are coming in the door. So my current estimate is I've stopped saying 2 to 3 years, and I'm saying 3 years or maybe even more.
Wow.
Or 3 to 4 years, which is a long time for people to plan ahead, especially when it's October, November, and they want to be out hunting, and they're like, my buddies are going to camp. It's like, well, not you this year.
Yeah, I get those questions a lot around closer to hunting season. Will I have this done by the time? Can I get deer tag? And I say, well, it's a long process. Now, it's not a pardon process length. I mean, I think most of my clients are under a year from when we file, but it's still a long process. So I say, hey, if you miss one season, you miss 2 seasons. That's not good. But if you get to go to the next 40 seasons,
Yeah.
it'll make up for it, hopefully.
I believe, I have never done metrics on this, but I believe a lot of clients with disabling felony and misdemeanor convictions are probably carrying a compound bow through the woods.
Well, I don't know. I can see it.
Well, we know they're going to be hunting one way or another.